Hello and welcome to this edition of Inside the Courtroom, the Senzo Meyiwa murder trial wrap. As always, I'm Linda Mnisi. Now, Tuesday was D-Day for Mthokoziseni Maphisa. That's accused number 4. The Pretoria High Court handed down a ruling on his Section 174 application, which he brought after the state closed its case. He brought the discharge application on the grounds that he believed that there were no prospects of a possible conviction. Advocate Zitulele Nxumalo cited a number of issues that he said pointed to how the state virtually had no case against his client, Mthokoziseni Maphisa, and should therefore be granted a discharge. Judge Rata Mokgwatleng started his ruling by looking at the legal test for a discharge application.
Section 174 of the Criminal Procedure Act 51 of 77 provides as follows: if at the close of the case for the prosecution at any trial, the court is of the opinion that there is no evidence that the accused committed the offense referred to in the charge or any offense of which he may be convicted on the charge, it may return a verdict of not guilty. The question whether a court should grant a discharge at this stage of the proceedings, that means at the stage where the state has closed its case, is one which has entailed a lot of debate and also entails that the court use a judicial discretion in arriving at the vexed solution. Pursuant to legal authority regarding the interpretation of Section 174, it is established that no evidence does not mean no evidence at all, but rather no evidence on which a reasonable court acting carefully might convict.
Both parties in the application agreed that the credibility of a witness in a Section 174 application plays a minimal role.
In the application, an evaluation of Section 174 of the Criminal Procedure Act, it has been held that credibility of state witnesses at this stage of the proceedings only plays a very limited role. It was stated in S versus Mpeta that the relevant evidence can only be ignored if it is of such poor quality that no reasonable person could possibly accept it.
The court said the evidence, however, needed to be evaluated holistically.
When a court refers to the evidence which it has to evaluate, it means the totality of the evidence in question, not pick and choose, cherry pick. It means the total evidence. Like in this case, we've been sitting for about 3 years. And I'm told there are about 60,000 pages of evidence so far. So when this court talks about the evidence, we're talking the composite tablet or tableau of all the evidence. Because evidence is interlinked, and evidence sometimes can support other aspects of the plateau of evidence which encompasses evidence in a trial.
Maphisa and his co-accused are facing charges of murder, attempted murder, robbery with aggravating circumstances, and unlawful possession of a firearm and ammunition.
The state has preferred to charge all the accused before us by the invocation of common purpose in the alleged commission of all the charges with which the accused stand before this court. Consequently, it would be useful to grapple with what the state intends to put as a legal principle to be overcome by the accused. Common purpose, that is an act of one participant in causing of the death imputed as a matter of law to other participants, and the causal connection between the act of each participant in causing the death of the deceased need not be proved. If you invoke the concept of common purpose.
Mokgwatleng highlighted Maphisa's arguments, saying they focused primarily on the evidence of state witness Constable Zungu, who placed the accused at the Phosphorus hostel.
This application, it's a limited application. It's not an application based on the whole evidence. It's not. When I read it, it's limited. For instance, it is only limited in broad swathes and sweeps against Zungu to say that his evidence is fatally flawed, his evidence is contradictory and can't be relied upon, and his evidence is as good as non-existent. Nothing is said about other contentious issues. For instance, in this case, there was a ballistic evidence. 4 or 5 ballistic experts testified here in this court, amongst whom they were led by Mangani, Serrero, and the others. There was also here cell phone evidence, which was testified to by 3 or 4 experts, House, Stein, Pinky, Palinthim. Nothing is said about that evidence.
He also highlighted the confessions by Maphisa's co-accused, Muzi Sibiya and Bongani Ntanzi.
And there's also evidence. You may term it confession evidence, or you may term it statements which were made by some of the colleagues of accused number 4. And there was pointing out evidence. And there was a full, I think 4, 5 trials within a trials concerning the admissibility of that exigency of evidence, depending on whether it was pointing out or other aspects. For instance, this court ruled that that evidence, the aspect of the evidence in this trial, should be placed on record, meaning it is still up to the accused to assail that evidence, if they still believe that this court misdirected itself. But that evidence still exists and is on record.
The deponents of the statements, Sibiya and Ntanzi, objected to the admission of the statements, triggering a trial within a trial, which looked into whether these statements were obtained lawfully. They claimed that the statements were given under duress, but the court, in an interim order, ruled that they were made freely, voluntarily, and without any undue influence.
I'm pertinently referring to that evidence. because it's still alive and live in this court, and it has not been analyzed in the application which has been launched by my brother, advocate. More so because, like I say, it is still live. It affects certain of our accused friends and brothers here. It has not been, as the law requires, subjected to a counter application because of new facts which could have come to the attention of the accused before court. And I'm saying this because it is right that in our law, in the case of Key versus Attorney General of the Transvaal, Kriegler at the Constitutional Court surmised that in South Africa, despite the fact that, or in spite of the fact that we have a constitution which guarantees rights to a fair trial in terms of Section 35 of the Constitution, there remains still a tension in our law, whether, even though the dictates of our law state that generally, if evidence has been acquired unlawfully, unconstitutionally, it shouldn't form part of legal proceedings in our country. And Kriegler says, because of this tension in our country, that sometimes, even if evidence is acquired, collected unlawfully, it may be in the interest of justice to do that and to make this evidence applicable in our jurisprudence. Consequently, we all know that there's a concept which says a court may sometimes admit evidence in the interest of justice, despite the fact that it was acquired unlawfully and unconstitutionally.
After the break, we continue with the ruling. Stay tuned. Welcome back. You're still watching Inside the Courtroom, the Senzo Meyiwa made a trial wrap. I'm Linda Mnisi. Now, Judge Rata Mokwatleng turned his attention to the evidence of Constable Sizwe Zungu, the only witness who testified that he saw the accused at the Basotho hostel in Vosloorus on the day that Meyiwa was killed. Constable Sizwe Zungu is arguably a key state witness. The state considers the hostel as the place where the murder of the soccer star was planned.
It was argued correctly so by the accused number 4's counsel that Zungu was a single witness. But then the opprobrium which is outed by counsel is that because he's a single witness, despite the fact that the court is enjoined to examine and evaluate his evidence to see whether his evidence is as a single witness. Is found to be materially sound. And that if that is the case, obviously the question is, what will the court do about that? If it is sound and satisfactory in all respects, and consequently also it is material. Evidence must be material in order to be sound in all material respects.
The court evaluated Zungu's evidence.
If you analyze Zungu's evidence, he says he was invited by a gentleman called Gwabeni to come to a celebration at Basotho Hostel. Because they will be having a party where there will be homeboys and they'll be celebrating, having eats and alcohol. And he duly arrived between 2 and 3 in that particular Saturday on the 26th of October 2014. And he says he was introduced to some of his homeboys. There were several of them there. Some he had met when he was still quartered in the rural areas. But subsequently, he became a policeman. He came to Joburg. He lost touch with them. And his evidence is that as a result, Gwabeni had to remind him, this is Racha, this is Mnisi, this is Baloi, this is Buthelezi. And he's excoriated for undertaking that trip, that memory trip with Gwabeni. I don't find it startling to be reintroduced to a person I last saw 10 years back. Some of them he remembered their names, some of them he did not. But what is critical and material for the evidence, as it will show later maybe when other evidence is being led, is that he says at that confabulation he met or saw accused number 1, number 2, number 3, number 4, number 5. Saw them and met them and engaged them and spoke to them. And even went to buy alcohol with them at Tops's bottle store. In my view, that is material evidence, critical evidence, because it relates to living human beings, live human beings. It's not relating to a car or a bicycle. Zungu says he was together with accused 1, 2, 3, 4, 5.
The court highlighted that Zungu testified about a close interaction with Maphisa at the hostel, where he gave him his car keys after Zungu was asked to move his vehicle. He said Maphisa clapped his hands as a gesture of thanking him. Mokgwatleng notes that's how close Zungu claims to have been with him.
Zungu says, at some stage, because there was no alcohol, Jameson was finished. The guys were drinking like fish. They went to go and buy alcohol, and they partook of that alcohol. And there's a piece of evidence, I don't think it's that important, but it is there, that accused number 4 bought some alcohol on that day of the 26th of June 2014, on the same day. Is that corroboration or not? Because Zungu says, I drank bottle upside down. We went to go buy some more liquor. Accused number 4 was with us in that red car or white car. He concedes. He says, I'm not sure. It could have been red, it could have been white, but it's a small car. So unlike a witness who comes to court and says we were there in a Rover 4x4. He said we went there in a small car. When it was pointed out to him that actually that car is in one of the photos and it is red, then he says, if it's so, it's possible. I did not particularly take care of the colors. At that time, the exigency was, we were just enjoying ourselves.
Zungu testified that the accused disappeared at the hostel in the evening and later came back in haste, seemingly disturbed and shocked, then proceeded to his nephew Gwabini's room, where he said he saw firearms being handed over to his nephew. This is where he said he had also stored his service pistol after his arrival at the hostel. He said he also noticed that Ntanzi had changed his hoodie. The court previously heard that one of the intruders in the Khumalo home was wearing a hoodie.
At that stage, number 2, I think, was handing over a .38 to Gwabeni. And number 3 was handing over a 9mm firearm to Gwabeni. He saw that with his eyes, that's what he says. And he says, it surprised him and shocked him because he was aware that Gwabeni is being sought or is facing charges for having murdered a particular gentleman using a 9mm. Now, Zungu is perturbed. He says, you're still messing around with firearms. What are you doing with this firearm? Didn't you use it to kill Snooki, or we'll remember the name just now? Then Gwabeni says, no, this is not the one that killed Rata or Snooki. The name is not important. This is not the one. That one I threw into the river or the dam, the one he used to kill a companion of theirs. He threw it away. He examined his own firearm because he suspected it could have been used in the manner, and I don't want to mention the switch, but that is the evidence. Because he says he was aware some people being Kabi. That's why he went and smelled his firearm, whether it has been used or not.
The court says Zungu, in his evidence, although making mistakes, does not change the main role players.
Zungu, apparently when he made a statement, it is before he was cross-examined on this aspect, he corrected himself, or he corrected the person who was making the statement, because she had written that when he entered Gwabeni's room, it was accused number 1, 2, and 5. In other words, after 1, 2, and 5 entered the room, thereafter 3 and 4 followed. But he says, no, the sequence is wrong. It was 1, 2, 3 who entered first, followed by 4 and 5. Now he's excoriated for being untruthful. But you know what? The forensic scientific result of this piece of evidence is he doesn't change the sequence of the players. He doesn't say there was Rata, there was Nisi, there was so-and-so. But when you write your statement, you mix up those characters. He mixes up the names, not the human beings. The human beings are constant. They remain accused number 1, 2, 3, 4, 5. He just mixes up the sequence as to whether 1, 2, and 3 went in first, or 1, 2, and 5 went in first. Of course, it's a mistake. I don't know, that mistake proves that he's a hopeless witness. Because like I say, the 5 accused remain alive. It's different if another accused or some other person who didn't put into the same aspects of the 5, assuming, let's say, Khotsosom Tunzi, he could have said 1, 2, 3, and then put in Khotsosom Tunzi. And then we discovered that actually Khotsosom Tunzi was never there. But the persons he enumerates, they are there from the beginning up to the end of the party.
The court also highlighting that while Zungu made mistakes about some of the aspects, some of his evidence was corroborated by independent evidence, like the cell phone evidence from Vodacom.
Photographs were taken at false lures. Accused number 4 concedes. I don't know why he had to do it. He says his client aligns himself with the evidence regarding directions of, I think it's number 5. Yeah, sorry, what was it? I assign my what?
Align himself with the cell phone records of accused.
No. He says he assigns. I'm sorry, I'm not supposed to ask you. But I just want to use the word. He
Aligns.
yeah. He says that is number 4, saying he aligns himself with the cell phone path of some of his colleagues. But the point I'm trying to make is there were photographs taken. We all know them. Exhibit S. Zungu himself says he was taken a photograph. There was some debate between himself and I think Mr. Mnisi to say, no, this is not you. And he says, look, it's me. I know myself. This guy has got 65 teeth. He must know himself. He says, it is I here, Imilo. I can see myself. I'm here. He misconstrued some of the faces of the persons there. But what is important for this exercise is photographs were taken on the same day, during the same spell of time, by Pinky.
The court asks if the photographs don't serve as corroboration.
Is it not corroboration that Zungu, who is supposed not to have been there, it was put by various counsels here, that you were never ever at Basotho Hostel. And we also were never at Basotho Hostel. But suddenly there are photographs.
The court also turned to cell phone evidence.
The evidence here, which is not contested, is that after Senzo was murdered, everybody panicked. Senzo was taken to hospital, Bophelong. Unfortunately, he loses his life there. The police subsequently returned on the 26th in the evening, and even on the 27th, they are busy with investigations. But what is telling is this. All the people who were inside the house, their cell phones were taken and they were downloaded. And there is proof beyond doubt that all those cell phones gravitated after Senzo was shot towards Bophelong Hospital. All of them. And when they came back, the cell phones were taken, obviously. But they first gravitated to the hospital. But no cell phone of Mrs. Kelly Kumalo went to the hospital because somebody took it, robbed it, and went the opposite way. That's where it was deactivated, to show that its trip was never to the hospital. It was only away. And that shows forensically, according to the experts, that that cell phone was actually robbed.
Advocate Nxumalo argued that Zungu's evidence was not corroborated and was marred by material contradictions which affected his credibility.
Mr. Nxumalo says in his heads of argument, for instance, 14.12, in respect of the factual evidence of Zungu's evidence, the contradictions are material and affect his credibility. Assuming the learned counsel is correct, is he prepared to say, therefore, his evidence amounts to nothing? Nothing. Nothing. He never went to the Basotho Hostel. He never saw accused number 1, 2, 3, 4, 5. He never went with accused number 4 and 5 towards Tops to buy alcohol. He never went and took photographs. They say it's near some building, let's say, or whatever. And there are photographs to that effect. We all saw them. And he says, yes, I didn't know who's taking the photographs. But it was put to him that, hey, the name of the guy who's taking the photograph is so-and-so, and he was there, and he was the driver of that red motor vehicle. So factually, that evidence, it has got corroboration, and scientific corroboration, cell phone corroboration, photographic corroboration. let alone physically, when you are saying they were traveling and they were speaking to whoever he spoke to, some woman there, what have you.
The judge also saying there is no dissenting evidence on the murder weapon.
There was other evidence also, ballistic evidence, which, according to the evidence so far, Manganyi testified thereto with rule of say. But the long and the short of it, that firearm, which allegedly was used to shoot, kill, murder Senzo, it has been identified beyond all doubt, all doubt. Ballistic science says no two firearms in the world are similar in their traction, their rifling inside, and even the bullets, the way they penetrate a particular matter, M-A-T-T-E-R, matter. No two firearms, that's science, it's not me, in the world are similar. And in their reaction, so when Manganyi says this firearm is a firearm that was used to shoot and kill and murder Senzo, we don't have dissenting evidence before us because, as I say, here we're still busy with a section 174 application.
Nxumalo argued that the state had seemingly changed tact on what it said its case would be, moving from a robbery gone wrong to a contractual killing allegedly ordered by Meyiwa's then-girlfriend, Kelly Khumalo.
Ginina says she's the one who arranged for the taking of the confessions by accused 1, 2, and the pointing out by 2. So in terms of section 2181, Ginina was able to read the confessions of accused 1, 2, and the pointing out of number 2. Because after arranging for Mbodlo to take down the confession and Rapadu to take down the confession, and Mrs. Kronje, the magistrate, for taking down the confession, he could read and see what is written there. And as a result of that, and he is not disbarred from having access to those confessions. The fact that he's an investigating officer is neither here nor there. He got information through reading those confessions that this was a planned, premeditated hit. It was not a robbery gone wrong.
The court found that the claim that Zungu's evidence was fatally flawed and a write-off was without merit.
I find that there is prima facie evidence which needs an answer. There is. And I don't have to delve into those other aspects. And consequently, I cannot discharge my learned colleague of number 4. There is evidence which a reasonable litigant has to discharge.
After the break, we get some legal analysis. Don't go anywhere. Welcome back. Now, last week, our legal analyst, Kabelo Siabi, took us through the arguments made for and against the granting of this discharge application. And now we have the ruling, and he gives us insights into what it all means. Take a look.
Kabelo, thank you so much for your time. We've come back again to now dissect the ruling that was given by the court this past week. The judge seemingly highlighting what one may read as shortcomings in the application that was brought by Advocate Nxumalo, saying that it was limited, to perhaps Zungu's evidence, and he would have liked to hear about the other aspects, highlighting issues of confessions, highlighting the issue of ballistics. Do you think that was important? Because he says it's trite law that he should look at evidence holistically, but also most importantly, because they are charged under the doctrine of common purpose.
Thank you. I think the departure point, Linda, would be that this was an application for discharge in terms of the provisions of Section 174. Now, when the application was launched on behalf of accused number 4, it was on the premise that there is no evidence on which accused number 4 may be convicted. Now, I think what the judge was pointing out was that the evidence that is before the court must be looked in its totality. And when one looks at its totality, one cannot come to the conclusion that there is absolutely no evidence on which he can be convicted. But one must bear in mind that this judgment was not about whether the accused is in law guilty or not. It was merely a test as to whether there is evidence on which he can be convicted.
So even the credibility then of Zungu was not in question here, given that he also focused on Zungu and the corroboration. It seems to have started a debate about whether or not the judge believes the evidence of Constable Zungu.
The issue of credibility only plays a limited role in a 174 application. For instance, if a witness goes into the witness box and when they are asked questions, they depart from their version, they give totally contradictory evidence, and basically their whole evidence is broken down. In that instance, the court will say, there's no way anybody can convict on the basis of this evidence because it's of such a poor quality. So credibility does play a role, but a very limited role. Now, what the judge was trying to point out is that Zungu's evidence cannot be dismissed in total because there are safety nets for certain of the things that Zungu has spoken to.
And those would be some of the things that are even corroborated by the independent evidence, like the cell phone records.
Yes, so the judge was pointing out that Zungu's evidence of being present at Basotho Hostel is backed up by the cell phone conversation. The fact that some of the pictures of the vehicle that he spoke about were taken. These are things that when one looks at it, one would have to now look at that and say, was Zungu present at the hostel or not? Has Zungu said things that can be independently verified to say that he was at the hostel? Now, if he was at the hostel, can he be believed that he was with the accused? And that is what the value of those quotations about the cell phone evidence is concerned. But then again, the judge also alluded to the fact that the statements in the confession that relate to that accused number 4 can be looked at, and he pointed out that in terms of section 218, if things are discovered as a result of an inadmissible confession, the court can still entertain those. And that is where he was going with that ruling that he made.
Should the other accused be concerned by this, given the fact that, he mentions that the discovery of the alleged involvement of accused number 3, 4, and 5 came through those confession statements? And while the argument has been the confession statement can only be used against the deponent, we now know there are statements perhaps of fact that, when the judge looked at them, found that these are issues that were discovered, like you say, from the confession statement. So should the accused be worried, even though they did not depose these confession statements?
You must remember that what the ruling means is that the judge says there is evidence on which they may be convicted. Now they would have to put up a defense to show that the evidence that exists is not of a standard that is required in criminal matters of being beyond reasonable doubt, and therefore they should be found not guilty. So where matters stand now, the accused would have to put up a defense. You see, if they leave the case as it is, it means that the only evidence to be looked at is the evidence that is put by the prosecution, and that evidence would stand unchallenged.
Let's say, for argument's sake, Advocate Mumalo brought this application knowing that perhaps it may not succeed. Do you think it would be a great strategy on his part to sort of gauge what the court's or the questions that the court has about the evidence that has been brought, particularly when you look at a witness like Zungu? One may argue that Zungu is possibly a key state witness. Do you think it would have been smart and perhaps strategic to get a sense, really, of some of the questions that the court is asking itself, so as to know how to put and align their case?
Look, the rulings that the judge has given as to the fact that there is evidence is a very great pointer as to what is in the mind of the judge. The fact finder has now indicated to say, I think there is something on the table. Now, obviously, once that has been done, you would have to see how do you navigate around that which is now being said to be there against you.
And I mean, when you look at just also the charges themselves, one thing particularly stood out for me when it comes to the issue of the confessions, the ballistics evidence, which he says at this point remains unchallenged. And when you also look at the issue around what was said in the confessions around Mthokoziseni having allegedly given Gwabini a 9mm, and all of the other elements that are contained where ballistically, they speak to, according to the state, the fact that accused number 3 could be involved. Do you think this is more reasons why then Dave Petersen should come and testify in Mnube's case?
The judge in his ruling on the 174 indicated that with the ballistics, he now has formed the view. It obviously is a prima facie view that the gun that was recovered is the murder weapon. He said it as plain as daylight. So now, obviously, it becomes critical for the defense to now come and rebut that prima facie view that the judge has already expressed.
Let's talk about the options now. I mean, now that the Section 174 from Mnube has not succeeded, the option is open your case, call their own witnesses. What would be the dangers of particularly the accused persons that have confession statements not taking the stand?
The problem with the first and the second accused whose confessions have already been ruled admissible is that a confession amounts to an admission that you have committed an offense. Now, unless you overturn that uppercut, the problem is that you will be convicted. So as far as they are concerned, they have to put up a defense.
And the defense would have to include perhaps them taking the stand?
Unfortunately, where matters stand with those two and particularly because their confessions are already taken in, they would have to put up a defense, and in my belief, I think they would have to testify.
How do we then reconcile the idea that if the accused choose to remain silent, then the evidence that is on the table right now would, for lack of a better word, be accepted as the only version that is put, right, and may somewhat work against the accused when the onus is on the state to prove beyond reasonable doubt? Explain to us how that works.
The onus in a criminal case always remains with the prosecution. It's the prosecution who must prove, and in a criminal case, they must prove beyond reasonable doubt. Now, once the state has put evidence, now that evidence, once it is before the court, it must be analyzed by the court. The court must look at the trustworthiness of the evidence, must look at the probabilities in that evidence, and when that analysis is done, it has to be a comparison of you look at the evidence on the part of the state, you look at the evidence on part of the defense. If there's no defense evidence, the only evidence under scrutiny would be that of the prosecution. Although you may find that there were things that are a little out of place, the fact that there's nothing to compare it against might end up with that evidence being totally accepted as it stands because it is unchallenged.
At this point, the state seemingly is on the right track, one might argue. What are the things that perhaps may, if they want to continue on this track, what are some of the things that perhaps they may need to look out for, given that the 174 ruling is not a judgment really of the entire trial?
Once the defense has now elected to put up a defense, obviously the state still has the burden of showing that the defense that is being put is false and stands to be rejected by the court. So it's not that the state's work is done. Even if the defense put up a defense, the state still has to show that the defense that has been put, it's false and must be rejected by the court. So there is still that work to be done.
Do they have a responsibility of closing every avenue that may arise?
No, but if the evidence from the defense creates a doubt, then the accused are supposed to be given the benefit of the doubt and be found not guilty. So that's why I say the state still has an obligation to try to show that the evidence that the defense would put before the court, that evidence is not to be accepted and must be rejected.
That was Kabelo Siabi, our legal analyst, taking us through the ruling and possibly what we can expect next. The defense has now been given 2 weeks to consult with their witnesses before opening their case. Now, the trial resumes on the 22nd of September, with Advocate Charles Mnisi expected to call his first witness on behalf of accused number 1, that's Muzi Sibia. You and I, though, will see each other again next time for another wrap of the Senzo Meyiwa murder trial. Until then, have a good one.